Most respected Srimati Sumitra Dhulia, wife of late Justice K.C. Dhulia, my esteemed colleague from the Supreme Court, Justice Chandra Sharma, my former colleague and my very dear brother Justice Sudhanshu Dhulia, former Judge Supreme Court of India, distinguished sitting and former judges of Uttarakhand High Court, Professor Sunil Rai, Vice Chancellor, UPES, Madam Richa Mishra ji, Director, Forest Research Institute, very eminent, distinguished personalities of Garhwal and Dehradun region, who all of you are here to grace this event, Shri Himanshu Dhulia and Shri Tigmanshu Dhulia, both sons of late Justice K.C. Dhulia, other family members of late Shri Justice K.C. Dhulia, members of the legal fraternity, distinguished guests, eminent professors, academicians and jurists, and most important for me, my dear law students. It is both a privilege and a deeply humbling experience to deliver the second Justice Keshav Chandra Dhulia Memorial Lecture in this historical auditorium of Forest Research Institute, Dehradun. I have always believed that memorial lectures, if they are to be truly meaningful, must do more than mere recount the achievements of those in whose honor they are instituted. They must seek, however imperfectly, to engage with the moral universe that shaped them, the values they lived by, and the quiet yet enduring influences they leave behind. For it is that deeper understanding that we discover not only the contours of their legacy, but also the measures of our own responsibilities. Today, as we gather to remember Justice Keshav Chandra Dhulia, we are confronted with a unique legacy, one that is at once incomplete in its judicial expression, yet profoundly complete in its human impact. Justice Dhulia's life reminds us that the measure of a jurist is not always confined to volumes of reported judgments. Sometimes, the truest legacy of life lies beyond the courtroom, in the values one nurtures, the integrity one lives by, and the lives one shapes. Born in November 1929 into a household steeped in public spirit and intellectual courage, Justice Keshav Chandra Dhulia inherited a rich legacy. His father, Shri Bhairavadat Dhulia, was among the foremost freedom fighters of the Garhwal region, who was even jailed for many years during the freedom struggle. He was among the founding editors of Karambhumi Saptahik, which was known for its independent and courageous editorials during colonial India. It was a time when speaking truth to power was not merely an act of courage, but an act of defiance. From such a lineage, Justice Dhulia imbibed a deep commitment to public service, intellectual honesty, and fearless engagement with the world. His academic journey took him to Allahabad, which was then a crucible of legal and intellectual thought in India. From there, he began his legal practice at the local court at Lansdowne before moving to Allahabad High Court, where his abilities, diligence, and integrity earned him huge recognition. He rose to become the chief standing counsel for the state and eventually he ascended to the bench in 1984. And yet, even with only a brief tenure of just 8 months on the bench, his judicial career bore unmistakable promise. In that short span, he was part of benches that delivered noteworthy judgments reflecting both clarity of thought and depth of conviction. He was also widely regarded for his diligence and efficiency, particularly in ensuring the early disposal of cases. We often measure judicial greatness by the longevity of service or the volume of jurisprudence. But perhaps there is another, quieter measure. It is something that resides in the unseen, in the influence that extends beyond written words. In that sense, the life of Justice Dhulia was not curtailed, it was continued in more than one ways. It is reflected in the extraordinary family he raised with his equally accomplished and inspiring wife, respected Mrs. Sumitra Dhulia, a distinguished professor of Sanskrit. In her continued commitment to public service, she serves as the chairperson of the Karam Bhumi Foundation, which has not only organized this memorial lecture but also contributed meaningfully to initiatives aimed at the welfare and development of Uttarakhand. Together, they built not just a household but a tradition of excellence. The three sons stand as living testaments to that legacy. My brother Justice Sudhanshu Dhulia adorned the highest court of the land. Mr. Himanshu Dhulia served the nation with distinction in the Indian Navy, and Mr. Tigmanshu Dhulia has carved out a unique space in Indian cinema as an actor and a director of remarkable depth. Each of them, in their own domain, has achieved distinction, but more importantly, each reflects a certain intellectual independence, a certain seriousness of purpose, a certain commitment to excellence that does not arise by accident. It arises from upbringing, it arises from the values lived, not merely taught. It is said that truth and true worth of life lies not in what it accumulates, but in what it inspires. Justice K.C. Dhulia's life inspired us to look beyond the visible markers of success and to recognize the deeper current of influence, of character, of integrity, and of strength. And therefore, we have a living legacy of character, discipline, and public service. It is from this deeply human and profoundly instructive legacy that we must now, ladies and gentlemen, turn to the theme that brings us together this afternoon: legal awareness and access to justice. In fact, when I discussed with Justice Sudhanshu Dhulia the theme on which I should share my views, eventually I realized that the amount of contribution sacrifices made by late Justice K.C. Dhulia, and that he was known to be a judge for the common masses, I deemed appropriate that I should speak on a subject which must be close to his heart also. And that's why I chose legal awareness and access to justice, the theme. I will try to share my views very briefly. When the Constitution of India was being debated, there was a clear and conscious recognition that the mere articulation of rights would not suffice. Among the voices that raised this concern with clarity was Ms. Hansa Mehta, one of the members of the Constituent Assembly. There were 15 women members. Nowadays, we respectfully address them as the mother of the Indian Constitution. She cautioned that rights, unless translated into the lived realities of citizens, risk remaining formal declarations present in text but absent in experience. That insight, though expressed in the formative years of our republic, continues to define the central tension of our constitutional journey: the distance between the law promises and what the citizen experiences. The Constitution does not conceive of justice as an abstraction. It envisions justice as a lived condition, something that must be experienced by every citizen, irrespective of social or economic standing. Article 39A gives institutional shape to this vision by mandating that the state shall ensure that the operation of the legal system promotes justice based on equal opportunity, and that free legal aid is provided so that no citizen is denied access to justice due to economic or other disabilities. This provision has been consistently interpreted by constitutional courts as imposing a positive obligation on the state to remove barriers, economic, procedural, and informational, that stand between the individual and the justice. This is not a matter of policy preference, it is a constitutional command, and yet, more than 7 decades after independence, the question that confronts us is not whether institutions exist, but whether they function in a manner that makes justice meaningfully accessible. India today has one of the largest judicial systems in the world, with over 25,000 judges, judicial officers across the district judiciary, high courts, and of course the Supreme Court, and a caseload that exceeds almost 5 crore pending across all levels. These numbers are not merely statistics, they reflect the scale of demand placed upon the justice delivery system and the urgency of making that system more responsive, efficient, and accessible. Ladies and gentlemen, I may just out of context clarify that sometimes there is a misnomer and a misconception that there are arrears of 5 crore. That is not true. A case which is filed today is Sunday, tomorrow Monday, if a case will be filed tomorrow, in the evening by 5 pm, the National Data Grid System will add that case in total pendency. But do you think that a case which is filed on that very day will become an arrear? I think all of you will agree that there is a difference between pendency and arrears. Arrears are only those cases which are ripe for final disposal, and if at all on account of long pendency, if their turn does not come and the courts are compelled to give certain adjournments and those matters are eventually taken up as per their queue, that may be counted as arrears. And if applying this yardstick, which I have been strongly advocating after taking over as Chief Justice of India, I don't agree and I don't believe that the arrears are 5 crore. Only the arrears are only a substantial part thereof, but most of the cases are only pending cases where the common law procedure, the statutory procedure that Indian legal system commands are required to be followed, and if you follow those principles which are in conformity with principles of natural justice, those cases will take their reasonable time for disposal. But significant institutional efforts have been made to bridge the gap even between the cases which are pending or which have been termed as arrears. The National Legal Service Authority and the network of state legal service authorities have over the years expanded the reach of legal aid through legal aid clinics, paralegal volunteers, and targeted outreach programs. The Lok Adalat systems, which has disposed of crores of cases, has provided an alternative, less adversarial forum for dispute resolution, particularly for economically weaker sections. More recently, last year when I was chairperson of the National Legal Service Authority, I gave a slogan, mediation for nation, and it was not a mere slogan. I am using the word consciously. Initially I thought that let it be a kind of a statement that people will try to react and follow. But believe me that ultimately mediation became one of the commitment in the Indian judicial system. At all levels it was followed, and today I can proudly say that the expression mediation has entered every house where there is a dispute worth resolution. Parallelly, the judiciary has undertaken an ambitious process of technological transformation. The e-court mission mode project, now its advanced phases, has led to the digitization of case records, introduction of e-filing, and the availability of virtual hearings. Yesterday only, National Conference of E-Committee has started, and in the morning yesterday while inaugurating, I have launched various e-technology based apps and modules and softwares through which now even service of notices in the matters which are being filed will be done without using the manual procedure which was the conventional practice, particularly at the taluka level courts and in the district courts. And we are quite confident that the apps and the software or the mechanism which we have introduced yesterday is going to help in a great way in expediting the procedural hearings. Today lakhs of cases are listed and heard through digital platforms, and judicial data is increasingly accessible through the National Judicial Data Grid, which provides real-time information on case pendency and disposal. These initiatives represent a significant shift towards transparency and efficiency. The executive, in collaboration with legal service institutions, has also launched initiatives such as Tele Law Program, which leverages common service centers to provide legal advice to citizens in remote areas through video conferencing. I am told that Telelaw has facilitated millions of consultations, particularly benefiting those who would otherwise have no practical access to legal counsel. Such initiatives demonstrate the potential of combining institutional reach with technological innovation. And yet, despite these efforts, a fundamental challenge persists. Access to justice cannot be measured merely by the existence of forms or the availability of schemes. It must be measured by the ability of individuals to meaningfully engage with the system. For a significant section of our population, the legal system continues to remain distant, not only in physical terms, but in conceptual and psychological terms. The language of the law often appears inaccessible, procedural, and all the procedural requirements seem complex and opaque, and the costs, both financial and emotional, are prohibitive. There is an anecdote often recounted in discussions on this subject. A villager, when asked why he had not approached the court for a grievance, might have responded, the court may be open for all, but it is not meant for people like me. That is the mindset created by the negativity in the system, that why a common man, a poor villager, a person marginalized, why do they feel that going to the court is not an easy task, or that it may not be meant for them, or that only a few elite group in the system can have and can afford the judicial system. That statement captures a fundamental truth. Access is not merely about entry, it is about inclusion. It is about whether the citizen feels that the system is designed for them, whether they can navigate it without fear, and whether they can understand its processes without dependence. Justice, therefore, must not only exist, it must be approachable. It must inspire confidence. It must be intelligible to those it seeks to serve. The challenge before us is not merely to expand institutions, but to humanize them, to ensure that the constitutional promise of justice moves from the realm of text into that of lived experience. So, what are the initiatives that need to be taken? I believe that legal awareness is the first pillar of access. If access to justice is the destination, legal awareness is not merely the path, it is the very condition that makes the journey possible. A right that is unknown in substance is a right denied. A remedy that is not understood in fact is no remedy at all. Legal awareness must therefore be recognized not as an adjunct to the justice system, but as its first and most indispensable pillar. In this context, the insights of Mrs. Renuka Ray during the Constituent Assembly debates acquire enduring significance. Another woman member of the Constituent Assembly. She cautioned that even the most progressive legal reforms would remain inert unless accompanied by a corresponding transformation in social consciousness. Law does not operate in abstraction. It draws its vitality from the awareness, acceptance, and assertion of those whom it seeks to serve. This understanding compels a shift in our approach. Legal awareness cannot be episodic, symbolic, or confined to periodical campaigns. It must be systemic, sustained, and deeply embedded in the fabric of everyday life. Awareness is not created through dissemination alone, it is cultivated through engagement, through dialogue, participation, and trust. It must begin early, within the education system, where the teaching of law is not reduced to technicalities but introduces young citizens to the language of duties, constitutional values, and rights. I am happy that very good amount of students are sitting here. I hope that they will get sensitized on this issue in their law universities. The legal awareness must be extended into workplaces where individuals are made conscious of their entitlements and protections in conditions often marked by asymmetry of power. And it must be rooted in communities where legal issues are not distant abstraction but lived realities requiring collective understanding and response. The consequences of this deficit in legal awareness are neither abstract nor remote. Consider the case of a young woman who believes that she has no right to refuse marriage arranged against her will. The law unequivocally does not stem from the absence of legal protection, but from the absence of legal awareness. In that moment, the distance between law and justice becomes starkly visible. Equally, there are countless instances where individuals suffer in silence, not because remedies do not exist, but because the very idea of seeking a remedy does not occur to them. Wage exploitation goes unchallenged. Domestic violence remains unreported. Entitlement under welfare schemes remain unclaimed. These are not failures of legislation. They are failures of communication, outreach, and trust building. In an age increasingly defined by digital connectivity, legal awareness must also adapt to new mediums of engagement. Technology offers unprecedented opportunities to disseminate information, but it also risks deepening exclusion for those who lack digital access or literacy. That's why there is a lot of hue and cry on digital discrimination. The challenge, therefore, is not merely to digitize legal awareness, but to democratize it, to ensure that innovation enhances inclusion rather than reinforce existing divides. This responsibility places a corresponding obligation on institutions, legal service authorities, civil society, education institutions, and of course the bar must work in connect to transform awareness from a passive flow of information into an active process of empowerment. The measure of success cannot be the number of awareness programs conducted, but the extent to which individuals are able to recognize, assert, and enforce their rights in real world context. The aspect is reimagining access in the digital age. Now, if legal awareness is the first pillar of access to justice, technology represents the architecture through which the awareness can be translated into meaningful action. Awareness illuminates rights, but it is access that enable their enforcement. The digital age offers us an unprecedented opportunity to bring those two dimensions into alignment, to ensure that knowledge of rights is matched by the ability to act upon them. We are living in an era defined by technological transformation. The digital revolution has fundamentally altered the way we communicate, transact, and engage with institutions. In India, this transformation has been particularly striking. The rapid expansion of digital infrastructure has created new pathways for inclusion, compressing distances that once appeared insurmountable. In this context of justice delivery, this transformation is not merely incremental, it is potentially transformative. Technology can reduce geographical barriers, lower transaction costs, and provide information in real time. It can simplify the procedures, minimize dependency on intermediaries, and make the law more intelligible to those who need it most. Properly harnessed, it can convert legal awareness into actionable empowerment. One may imagine some citizens in a remote village equipped with nothing more than a basic mobile device, being able to access clear and reliable legal information in their own language, to understand the remedies available to them, and to connect seamlessly with a legal aid provider without the burden of travel, delay, or expense. One may imagine digital platforms that demystify legal procedures, translating complexity into clarity and formality into accessibility. These are no longer distant aspirations, they are possibilities within our own immediate grasp. And I can again, out of context, happily announce that today only in the conference, Nalsa Regional Conference in Dehradun, the Uttarakhand Legal Service Authority has launched some apps, and that includes the mobile apps upon which you can have complete access, you can have legal assistance, you can have legal opinion, you can have legal aid counsel, and you can also find out the details of your case, pending case, or the opinion whether you should go to the court or not, including the pre-litigation platforms like mediation, etc. Now, at the same time, we must remain attentive to emerging risks that risks are brought by technology. As justice system move into the digital spaces, concerns of data privacy acquire increasingly significance. Access to justice cannot be at the cost of fairness, autonomy, or accountability. The design of digital legal systems must therefore be guided not only by efficiency but by constitutional values. Ultimately, even in an age of rapid technological advancement, we must remember that justice is not a purely transactional outcome. It is a deeply human experience. It is shaped by dignity, empathy, and the assurance that one has been heard. Technology can facilitate access, but it cannot substitute the human core of justice. The task before us, therefore, is not to choose between technology and tradition, but to harmonize them, to build a justice system where digital innovation amplifies human sensitivity and where access is not merely expanded but equalized. Only then can the promise of legal awareness, which begins as knowledge, culminate in justice that is truly experienced. The third thing I feel is towards an ecosystem of justice. If legal awareness is the foundation and technology is the enabler, then what ultimately sustains access to justice is an ecosystem, one that is collaborative, responsive, and anchored in shared constitutional purpose. Access to justice cannot be realized through isolated interventions or fragmented initiatives. It requires a coordinated and sustained effort across institutions, each discharging its role with a sense of collective responsibility. First, the judiciary. The judiciary, as the sentinel of constitutional rights, must continue to innovate not only in adjudication but in the design of processes that are accessible, intelligible, and humane. Procedural reforms the use of technology, and a continued emphasis on legal services must converge to ensure that justice is not delayed, diluted, or denied at the threshold. The executive, role of the executive, for its part, bears the responsibility of creating the enabling conditions within which access can be meaningfully realized. This includes investment in digital and physical infrastructure, strengthening legal aid institutions, and ensuring that policies are designed with an acute sensitivity to ground realities. Access to justice is not merely a judicial concern, it is a governance imperative. The third player, stakeholder, is the Bar Association, the members of the Bar. The Bar occupies a position of unique significance in the ecosystem. It is often the first point of contact between the citizen and the justice system. The commitment of the legal profession to ethical practice, pro bono service, and client sensitivity is therefore indispensable. The law at its most effective is not merely argued, it is guided, explained, and made accessible through those who practice it. Equally, academia, fortunately today sitting here, academic institutions, particularly the law universities, must assume a more active role in shaping the future of access to justice. Legal education cannot remain confined to doctrine and theories. It must cultivate a sense of social responsibility, encouraging students to engage with legal aid, community outreach, and the lived realities of those who remain outside the formal structures of justice. In doing so, it ensures that the next generation of lawyers is not only professionally competent but socially conscious. The other stakeholder is civil society organizations and community-based networks involved and those who complete this ecosystem. They operate at the interface between institutions and individuals, often reaching those who are otherwise invisible to formal systems. Their work in building awareness, facilitating access, and fostering trust is indispensable. In many ways, they give tangible form to the idea that justice must travel to the citizen rather than waiting for the citizen to find out it. What emerges, therefore, is not merely a framework of justice, but a philosophy that places the citizen at its center, one that is not confined to institutional response but is animated by facilitation and access. It is an approach where awareness becomes the first step towards empowerment, accessing the means of participation and asserting the pathway to meaningful enforcement. In many ways, this vision, ladies and gentlemen, resonates with the life and work of Justice Keshav Chandra Dhulia, whose own judicial approach reflected a deep and abiding commitment to making justice real, accessible, and responsive to those it seeks to serve. As we reflect on the life and legacy of Justice Keshav Chandra Dhulia, we are reminded that the true measure of a life lies in its duration, does not lie in its duration, but in the depth of its contribution. Some lives and some lives leave behind memories, others leave behind direction. His belongs firmly to the later. His journey stands as a silent but enduring testament to the power of integrity in public life. It reminds us that institutions are ultimately shaped by the individuals who inhabited them, and that values, one lived with conviction, acquire a permanence that outlasts time. In an age often defined by speed and change, such examples anchor us to what must remain constant. But remembrance by itself is not enough. The most meaningful tribute we can offer is not in words, but in the choices we make and the systems we build. This memorial lecture, therefore, is not merely an act of reflection, it is a call to action. It calls upon us to reimagine access to justice, not as an abstract ideal, but as a lived and measurable reality. It calls upon us to ensure that the law is not distant, but within reach, not complex, but comprehensible, not intimidating, but enabling. It calls upon us to build a system in which legal awareness empowers, technology includes, and institutions respond with sensitivity and purpose. If we can move, even incrementally, towards a framework where every citizen aware of their rights, confident in asserting them, and assured of a fair, timely, and humane response, we would not only be fulfilling a constitutional mandate, we would be strengthening the very foundation of our democracy. And in doing so, we would carry forward a legacy in the truest sense, not by preserving it in memory alone, but by giving it contemporary meaning. For the enduring tribute to a life of public service lies in ensuring that its values continue to find expression in the lived experience of those whom the law is meant to serve. Thank you very much, ladies and gentlemen, for your patience hearing. Thank you very much for giving this opportunity to me to be here with you and share my views. Thank you very much.